Welcome to our 2015 webinar series for the Support Anti-Terrorism by Fostering Effective Technologies Act of 2002. I'd like to start by welcoming you today and thank you for spending your afternoon with us. Today we'll be spending some time recapping what we have discussed in various webinars, including why you might consider applying for Safety Act protections, the Safety Act process, and the tools available to help you to submit a successful application, focusing on the different types of information typically submitted. If you're having trouble with the audio on your computer, you can always dial in. The dial-in information is on the left-hand side of the screen for reference. The slides from this webinar will be available for download at the end of the session. The audio for this webinar will be available for download at www.safetyact.gov in the future. If you are new to our Safety Act process, our previous webinars, slides, and audio can be viewed on www.safetyact.gov. Finally, if you have suggestions for future webinars, please let us know by sending an email to the Safety Act Help Desk at dhs.gov or let us know in the chat room at the end of this webinar. Now I'd like to turn it over to my colleague, Rachel Byrne, an insurance examiner for the Office of Safety Act Implementation. Rachel, good afternoon.
Thanks, Laura. Before we get started with our presentation, I want to explain the mission of the Department of Homeland Security and why the Safety Act exists. On September 11, 2001, in the worst terrorist attack in United States history, almost 3,000 people were killed, and our economy suffered a loss well into the hundreds of billions. The Department of Homeland Security was created in response to 9/11. Our duties are wide-ranging, but our goal is clear: a safer, more secure America, which is resilient against terrorism and other threats. Due to the extensive litigation concerns following 9/11, many sellers of life-saving technologies were either under-deploying or halting deployment altogether due to the magnitude of risk exposure they faced. The Safety Act is designed to protect concerned sellers of qualified anti-terrorism technologies and therefore protect American lives. To date, the Safety Act has approved over 700 anti-terrorism technologies, 30 of which have been approved already in this fiscal year. OSAI staff members will be available to address specific questions in the chat room during this webinar. We will also have some time at the end to address some of your pre-submitted questions. If you have more questions and need additional help to answer your specific questions, you can always contact OSAI, and when we say OSAI, we mean Office of Safety Act Implementation, via the Safety Act Help Desk at a later time. Now I'd like to turn it back over to Laura.
Thanks, Rachel. It's great to be here. So what we're going to do right now is start with what the Safety Act is, and possibly more importantly, what the Safety Act is not. As part of the Homeland Security Act of 2002, Congress enacted several types of liability protection for providers of anti-terrorism technologies. That's the central purpose of the Safety Act. The Safety Act provides incentives for the development and deployment of anti-terrorism technologies by creating systems of risk management, litigation management. The reason for the Act is to ensure that the threat of liability does not deter you, a potential manufacturer or seller of an anti-terrorism technology, for developing, commercializing, and deploying technologies that could significantly reduce the risks or mitigate the effects of large-scale terrorist events. Thus, the Act creates certain liability limitations for claims arising out of, relating to, or resulting from an act of terrorism where qualified anti-terrorism technologies have been deployed. The Act does not limit liability for harm caused by anti-terrorism technologies when no act of terrorism has occurred. For the purpose of the Safety Act, an act of terrorism is any act that the DHS Secretary determines meets the requirements under subparagraph B of Section 442 of the Safety Act, as such requirements are further defined and specified by the Secretary of DHS. The Act meets the requirements of subparagraph B if the act is unlawful, causes harm to person, property, or entity in the United States, or in the case of domestic United States air carrier or a United States flag vessel, or a vessel based principally in the United States on which U.S. income tax is paid and whose insurance coverage is subject to regulation in the United States, in or outside the United States, and uses or attempts to use instrumentalities, weapons, or other methods designed or intended to cause mass destruction, injury, or other loss to citizens or institutions of the United States. So that means that the Safety Act would not, for example, apply in the event of a natural disaster. It's not an all hazards program. Further, the Safety Act is not a regulatory program. Your participation is completely voluntary. But because we're non-regulatory, we don't really publish specific requirements. We offer you, however, our best technical opinions. We also aren't a test entity. While we ask for test data, we don't have the resources to conduct tests of your technology or provide grant money for you to test your technology. So I'd like to hand it back to Rachel to talk about the protections that the Safety Act offers.
So I want to touch on the protections offered by the Safety Act. The Safety Act has two primary levels of protections, designation and certifications. There's also a subset of designation called developmental testing and evaluation designation. However, I'd like to start in the middle of our figure with designations. Designations are for technologies that have demonstrated effectiveness during operational testing or prior operational use. Designation provides a liability cap as well as exclusive action in federal court, no joint and several liability for non-economic damages, and no punitive damages or prejudgment interest. If a technology receives designation, the applicant is required by the Safety Act to obtain liability insurance in the amount of the specified limit liability cap certified by the Secretary. A designation and an associated certification, which we'll talk about later, normally lasts for 5 years, after which time both can be renewed. Any technology deployed during its period of designation is protected for the lifetime of its deployment. Some technologies show promise but are not mature enough to be fully operational. The developmental testing and evaluation designation is available to provide protection during testing or trial deployment so that applicants can collect the efficacy data necessary for a full designation. A DT&E designation provides similar liability protections as that provided by a full designation, but with certain limitations and constraints. In general, DT&E designations will include limitations on the use and deployment of the subject technology, subject determination at will by DHS should any concerns regarding the safety of technology come to light, and will have a limited term not to exceed a reasonable period for testing and evaluating the technology, typically not longer than 36 months. Further, the Safety Act liability protections associated with DT&E designations will apply only to acts of terrorism that occurred during the period set forth in the particular DT&E designation. In certain circumstances, the department may find that a technology being evaluated for designation may not be mature enough for that level of coverage. In that event, the applicant may be awarded a developmental testing and evaluation designation, DTED. However, additional requirements may be associated with a DTED, such as submittal of a formalized test plan and a proposed test location to the Office of Safety Act implementation. Thus, an applicant may be required to resubmit a formal DTED application.
Great, why don't I pick it up and talk about certification a little bit? That's for technologies that have a high level of technical maturity and a history of deployment and use. Certification might be appropriate in those instances. In addition to the benefits provided under designation, certification allows a seller of an anti-terrorism technology to assert the government contractor defense that immunizes sellers from liability for claims arising from acts of terrorism. Technologies that receive certification will be also placed on an approved products list for Homeland Security. Certifications are valid for the term of the corresponding designation and can be renewed. Some of you might also be wondering about block designations and certifications. The Department of Homeland Security has established a streamlined procedure for providing Safety Act coverage for qualified sellers of certain categories of technologies. These types of certifications or designations are known as block designations or block certifications. Block designations and block certifications may be issued at the Department of Homeland Security's discretion and are intended to recognize technologies that meet specific criteria for designation as a qualified anti-terrorism technology or certification based on established performance standards or defined technical characteristics. Currently, approved block designations and certifications are posted on the website with details on streamlined instructions that for applicants to file such applications. Again, that list of active blocks are on our website, and so if you are an applicant, check those out. If you're an applicant or a federal partner who has an idea for a block designation or certification, please also contact us. We're always looking for new blocks to establish. You'll also notice our active procurement list. Those are technologies being acquired by specific agencies or participating government-sponsored programs, which might also be eligible for streamlined processing. So check that out too. And if you're a government contracting officer or a program manager and you think you might be acquiring a technology that should be on our active procurement list, also give us a call. We're happy to work with you to establish that process as well. Rachel, I was kind of wondering how many technologies have received Safety Act protections to date?
Well, switching topics a bit, we are often asked how many Safety Act approvals there are. So as of early January 2015, we've approved 724 applications. Because things expire or are replaced with new technologies at any given time, we typically have 300 to 400 active technologies with various levels of protection. At the same time, people often ask, what is the percentage of Safety Act applications denied? While we do not disclose exact numbers here, the percentage of denials is very low. To improve the chance for success, we encourage companies to start by submitting a pre-application. It does not take much time to fill out and opens a dialogue with our office. Once we understand your technology, we can host a teleconference to help guide you in the types of information necessary for a full application. OSAI is available to help you through the application process as much as possible and identify weaknesses in your application materials that might not be addressed early on. We will talk in a slide or two about the Safety Act timeline. However, one of the key concepts when navigating the Safety Act is early engagement with the Office of Safety Act Implementation, or OSAI. We like to think of ourselves as a little office that can. Though our program staff is small, we do our best to respond quickly to requests for assistance. So don't worry if it takes a little bit for us to reply to a request. We will get back to you.
All right, so let's take on the next topic, the type of Safety Act technologies that we're looking at. The Safety Act applies to any qualifying product, equipment, or service, typically including a support service, a device or a technology including information technology that's designed, developed, modified, or procured for the specific purpose of preventing, detecting, identifying, or deterring acts of terrorism or limiting the harm such acts might cause. As you can see from the application, the Safety Act applies to a wide range of products, services, and information technology solutions, provided they have an anti-terrorism capability. Technologies with Safety Act protections currently span many technology types, and they include sensors, integrated surveillance systems, venue security for specific locations, software solutions, logistics support and maintenance services, pharmaceuticals, and intellectual property. You can review the technologies on our approved technologies list to get a better understanding of the range of technologies that have and corporations that have Safety Act protections. More recently, people have asked about cybersecurity technologies. In FY 2014, the first cybersecurity technologies were awarded Safety Act protections, so those protections are available. However, given the dynamic cyber threat environment and evolving standards and policies, we do suggest that you file pre-applications for these technologies to get the most up-to-date information on cybersecurity type applications. So now that you have a little understanding of the protections, let's talk about the timelines.
So, how long will it take to apply and receive a decision? Well, that depends on a couple of things. First, there is no prescribed due date or window of time for you to apply. Businesses apply when they are ready and when they have all the materials that they think they need. It's kind of like cooking, even though my recipe for chocolate cake says it will only take 90 minutes. I still have to allow time to refresh myself on the recipe, go to the grocery store for ingredients, find the right size pan, prepare all the various layers, assemble it, and then put it in the oven. That can be a bit of prep work that isn't accounted for in our timelines. So we recommend that first-time applicants and veterans with a new type of technology file a pre-application. A pre-application review includes checking the amount and type of supporting data you have listed against the criteria described in the Safety Act, and noting the strengths and weaknesses of your proposed application. OSAI attempts to complete these reviews in 21 days or less. When the review is completed, you will receive a letter inviting you to take part in a teleconference with the evaluation staff to discuss the merits of your technology for Safety Act protections and to discuss what will be necessary to provide an administratively complete application. After a pre-application, it's up to you to gather the materials you need to complete the application form and submit the application. That can take as much time as you need. We will talk more about some helpful hints on the next slide. Once your application is submitted, OSAI will typically review your application and determine if there is enough information to move forward into the evaluation phase within 30 days of receipt. In most instances, you can expect to have a final decision within 120 days, calendar days, if your application is complete upon filing. While 120 days is our goal, some applications might take longer. If you have a very complex technology with many components or your technology is a first-of-a-kind submission, it can take a bit longer for us to complete. However, we will be in touch if that is the case. If you feel that 120 days might be too long because you have an imminent procurement, you may request an expedited review by filling out item D2 of the designation application form. The decision to grant an expedited review will be made by the director of OSAI. While we do strive to meet these expedited goals, sometimes they are very ambitious. We also rely on you to submit complete, accurate information at initial filing and respond equally expeditiously to requests for additional information. But what happens if our office needs more information to fully evaluate your technology? After 30 days after your submission, you will know if the application is administratively complete or incomplete. If you receive a letter saying that your application is administratively incomplete, not to worry. That letter will contain details of the types of additional information needed and requested and directions on contacting OSAI for further consultation. There is no timeline for refiling and no penalty for doing so. So finally, we think it's important to point out that there is no fee for filing the Safety Act protections. The only costs you will incur are those overhead costs associated with preparing an application and the cost of your insurance policy that would respond to third-party claims arising out of an act of terrorism.
Thanks, Rachel. It seems like there might be a lot of information that we're asking for, and I know that many of our applicants are concerned about supplying all this technical, insurance, and economic information. Well, to all of you out there, rest assured that OSAI takes information security very seriously. The Safety Act website is DHS CIO certified and accredited. However, the Safety Act website cannot process classified materials. So please contact the Safety Act Help Desk in advance of submitting your application if you wish to include classified materials. Also, if you have large amounts of information to submit or video clips, you should also contact the Safety Act Help Desk. We might need you to send in a CD or a DVD. We'll make sure that you have that number for the Safety Act Help Desk by the end of our webinar. And our contact information, as always, is available at www.safetyact.gov in the Contact Us section. We do suggest that if you have large number of files or large size files, that you contact the Safety Act Help Desk before submission. It is difficult for our office to begin work until we have your entire package, so any delays in obtaining data could impact our timeline. Further, as a favor to me, please remember we don't really try to work on weekends, even though we all do small program office, so submit on Mondays if you can.
Once you've registered, it may be tempting to log in and start filling out application forms. Before you begin, please take some time to look at our publicly available resources. The tabs, printer-friendly materials, and the FAQ section are useful resources to review if you have questions about the basics. Both tabs are updated periodically, so if you have not checked them recently, please do so to see the latest guidance and suggestions. So, where do you start? Often applicants ask, how do I even begin? I know one of the challenges I have on every project is knowing where to begin. So with the Safety Act, if you are brand new, the pre-application is a quick way to get started. If you think you have enough familiarity with the application process because of the information on our website, our webinars, or experience, then you may want to start with the technology description. Clearly identify what you are seeking Safety Act protections for, whether it is a product or service that is sold for profit or used internally for your business. Then begin listing all of the information you might have to support each component of your technology. As you list this information, you should also consider what type of Safety Act application would best fit your situation. DT&E designations might be appropriate if you have a new product that you are just beginning to pilot or deploy. A DT&E designation would give you protections while you collect additional information. Maybe you have some operational deployments, but not a lot of performance. Designation-only applications might be a good alternative. Or you might just want to file the designation and certification application right away. Once you have defined your technology and selected the application type, You should organize your materials, answer all the questions in the application forms, upload your materials, and submit your application. OSAI is able to assist you at any step along the way.
Hold on a second. You mentioned a technology description. I want to touch on that for a second because the most critical aspect of any application, no matter the type, is that technology description. But what really is it? A technology description is the what and the how of your technology and tells us who you are and what you do. We use the word technology as a term of art. Simply put, it means whatever it is that you provide or use internally that provides an anti-terrorism benefit, be it a sensor, software, a security plan, or whatever you're seeking protections for. We suggest you start by defining your baseline, anti-terrorism offering, and those elements that are customizable or optional. When describing your technology, try to keep it as simple as possible and do not use marketing language. We are looking for the facts. What is your technology and what are you seeking Safety Act protections for? It is important to be clear and concise in describing your technology. The technology description is what will be evaluated for Safety Act protections and what would eventually form the legal definition of your technology and be protected under the Safety Act. While reviewing your submission, we will ask you for information supporting all aspects of the technology description. For example, if you are providing access control and a security plan, we will want to see information on both.
Scoping your technology matters as well. For example, if your company is a security firm providing guards, we might have different questions if you serve a site that houses special nuclear material than if you serve a school or shopping mall. Also, focus on the anti-terrorism aspects of your business. Not everything your company sells or provides is an anti-terrorism technology, and that's okay. For some technologies, particularly security services and cybersecurity technologies, we have also found that if not in your technology description, then in your application, you should delineate the responsibilities of your customers in using the technology. What decisions can they make about how the technology might be employed? What components or functionalities are always sold and what are optional? What elements can be dialed up or down based on perceptions of threat? All of these questions are important to consider in drafting a technology description. Drafting a technology description is intended to be interactive. It is a collaborative process involving you and DHS to determine the most complete definition that can be reasonably evaluated as part of our review process. Also, please remember, if you make changes in the future or update your technology with more components, you might be able to modify those things later via notice of modification. So start with what you are doing today, not what you plan to do in the future, and focus your technology description on things that you can support.
Great. So moving on, what's the best way to organize an application? Well, once you have that technology description drafted, it's time to begin working on your Safety Act application. Recall that the Safety Act application process is largely based on paper submissions, so organization is very important. You have invested time, money, and effort in developing your technology, and you want to show us that time and effort on paper. One way to do that is to assemble a team within your organization to support the application. You should have technical and insurance points of contact, people who know your organization and how your technology was developed and how it works. Generally, there is no one right person to submit an application, there is a right team of people. Once you have assembled your team, work together to answer all the questions in the application kit clearly and thoroughly. As we've covered in other webinars, the Safety Act application kit consists of questions and instructions. Because the Safety Act covers a wide range of products and services, the questions are designed to capture all technology types. OSAI can help you understand how the questions might apply in your particular case. There are no wrong answers per se. What's important is that you answer all the questions and support your technology. As you develop your responses, think about what additional information you need to assemble to support those answers. Reference them in your responses. As we will discuss later, they can be documents like user manuals, training materials, test reports, standard operating procedures, hiring policies and procedures, and all sorts of things. You might also provide us with the names of customers or points of contact that can provide additional information. No matter what you provide, tell us a clear story with your supporting materials. If you have a lot of supporting materials, make sure that you include a table of contents. We recommend numbering attachments 1, 2, or 3, or using the letters A, B, C. Just make sure all of your attachments are listed in that table of contents, and that the file names match the documents you intend to upload. Also, be careful not to substitute quantity for quality. While it is sometimes tempting to add lots of attachments, consider how those attachments aid in telling us your story and what they add to your overall submission. It's a fine balance, to be sure, and one we're happy to help you with as you're preparing that information. Other things like using section headers, supplying that tables of contents, and giving us searchable PDF and Microsoft Word formats can also help us effectively and efficiently review your materials. Also, I tend to have a preference, everyone kids me, for Times New Roman 12-point font, but that's not a requirement. Another commonly asked question that we have is, can I submit a draft of my Safety Act application before formally applying? The answer is yes, of course. Typically, drafts are only reviewed after OSAI has had some preliminary communication with an applicant via either that pre-application process or a teleconference. To have OSAI review a draft, you must contact us via the help desk. While we do attempt to review drafts quickly, be advised that it can take several weeks. If you are submitting a draft, we ask that you provide a copy of the answers to your application kit questions and a list of all the attachments you intend to supply. You don't need to submit the attachments themselves unless they are specifically requested by the program office.
Okay, so how much information do you need to submit? All right, so the information needed to support your application vary by application type. For example, we would expect additional information in designation and certification applications versus designation-only applications because of the additional questions. However, we can give you some thumbnail guidance called the Define, Discuss, Document approach. Whether you are a first-time applicant or a veteran filer, please be sure to fill out all the introductory questions, items D1 through D8. Although you may have submitted several Safety Act applications, remember that each application stands alone. Information does not transfer from one application to another. Additional information, such as the registered point of contact for your company, may be different for each application. Completion of each individual item number in the application can provide assurances, but no piece of critical information is overlooked. This can make the difference between an application that is complete for evaluation versus one that is incomplete. So how much information should be included in the application? What is the depth of required information? How much is too much? We advise all applicants to begin with item D9 of the application. This is where you describe your technology together with all the elements, components, or services that are included when you make a sale or deployment. D9 is where you lay out your technology description. You can add more details than might end up in the ultimate definition, but details are good. You are describing your technology to experts in your field. They will all want to look under the hood, so to speak. You will also want to discuss your technology and the responses to the various questions that follow. You should provide enough information to support the capability and effectiveness of each product you manufacture or service you provide. You should also provide information that details the manner in which you provide what you sell. This would include manufacturing, procurement processes, and quality assurance processes, as well as all personnel policies and procedures. Well-crafted narrative responses to the questions in the application are essential. Simply responding to questions with "see the attached policy" or "see the attached test results" is typically insufficient and may result in an incomplete application. That's because without a narrative description, we have no context for your attachments.
All right, so I'm going to walk you through an example. So in response to D14 of the application kit, you are asked to provide information on technology effectiveness. You provide the response, see attachments 7 through 10, test data, with no description. An analyst opens up the series of reports and finds that in one instance, the technology detects a threat item 42% of the time, and in the next, it detects the threat item 91% of the time. Just looking at those two numbers leads to any number of questions, including what changed to give 42% detection in one instance and 91% detection in another? Why is there such a large difference? Was the technology even the same in both tests? Any one of these questions could have been avoided with a narrative response, such as, in 2011, we tested our product and found it had a 42% detection rate. Upon review of the data, we found that a number of changes to our software algorithm were needed. We engaged in additional development to fix the areas listed in Attachment 11, tested the software fixes internally, see Attachment 12, which contains the regression test results from the internal test described in Attachment 13, and reconducted the operational test in 2012. In this test, we determined that our technology had a 91% detection rate. That discussion right there tells me an awful lot about you. First, it takes your 2 test reports out of isolation and makes them part of your development history. Second, it tells me that you have a procedure to identify the cause of weaknesses, a method to correct those weaknesses, and that you have tested to verify that your fixes worked. That discussion is also supported by your documentation. But note how the narrative discussion provides the context for your documents and helps you determine how much information to supply. Use your narrative to help you determine how many documents to provide. And as we noted, this is a paper review, so please make your discussions as clear as possible. Remember that, again, we are always available to consult with you on the type and depth of information needed to support the submission of your application.
Okay, so what types of information should you submit for designation? As we touched on how much in the last slide, I want to spend a little bit of time outlining what type of information to submit. In general, what type tends to fall into one of 3 categories: development, capability, and effectiveness. We'll talk later about insurance. Development is really the story of your technology. Every good application begins with a discussion of how your technology came about. What's your expertise? What's your background? How was your technology developed? Maybe based on your insight and experience, you saw a need that wasn't being met in the private sector. Or maybe you're responding to a specific government request for proposal. How and why will your technology reduce the risk of terrorism? We need to understand if your technology is available for immediate deployment and that your technology, as described, has the capability of being an anti-terrorism technology. How do you hire people that can supply the technology? What processes do you use? What procedures? How do you test your idea? Was it based on scientific research and tested in a lab? Or was it developed based on industry or government standards? As you consider capabilities, start thinking of these materials you can submit to support your story. Those could be copies of policy documents, internal test reports or results, training slides with speaker notes, user manuals, etc. Once we have a good understanding of what you do and how you do it, we want to know how it's working. Effectiveness is simply our way of asking you to show us your successes. You might do this through operational testing of a product of a deployment history with customers who will provide feedback about using your technology to DHS. Please make sure that any customers or sources of information know that DHS will be reaching out to them and ensure that their contact information is current. Please outline what you expect from them to be able to address when OSAI calls them. Other ways to show success include incident reports from things that aren't terrorism related but might show the effectiveness of your technology. For example, maybe you have installed a chemical sensor that picked up an accidental spill of cleaning supplies. Or maybe your security guards stopped an intruder or responded to a medical emergency. Case studies of success backed up with incident reports and customer testimonials can demonstrate effectiveness. Sometimes the normal course of business might give you effectiveness information as well. Do you do a site acceptance test before delivering a software package or an integrated system? Great. Give us the plan and the customer acceptance documentation. That's evidence of effectiveness. There is no one-size-fits-all data package. So when collecting data relating to the effectiveness, ask yourself, how do I know what I'm providing works? How do I check with customers to make sure the technology is performing? That second question is about quality control. Do you have a quality control process? Can we have a copy of that document? Do you have the results of quality control inspections? This could include factory acceptance tests for products, or if you provide a service, periodic reviews and updates to processes and procedures.
That's great information about the designation application, Rachel. But what types of information should they submit for certification? Well, for certification, we want to see not just how your technology is effective now, but how it will continue to be effective over the long term. For example, do you have a plan for identifying problems and making changes? No company or technology is perfect. However, the important thing is, how do you recognize that sometimes something might not be working? How do you document your findings, and what do you do with those findings to make your technology better? Don't be afraid to show us your warts. We all grow and change based on experience, and we would expect that you do too. And finally, while the certification application has a specific question about safety, You might also want to consider discussing safety in a DTED or a designation application. Do you manufacture to a specific safety standard? Do you provide training to protect your operators or provide instruction on proper use of your technology? This is all important for us to know. Once we've talked about your story and your successes, we want to know what's next. That's the essence of a certification application. How are you going to expand and ensure that your technology is repeatable across a wide spectrum of deployments? How do you ensure that you will have the same high-performing technology everywhere you go? We call that repeatability. If you have the answers to these types of questions, you should be filing an application for designation and certification. If you don't think you can answer the certification questions right now, that's okay. You can always apply for certification later on after obtaining designation. For products, your answers might address the following questions. How do you know your technology is effective in the long term? How reliable is your technology? Metrics like mean time between failure or mean time to repair. How do you maintain your technology? Do you have a quality control or after-action correction procedure? What is your technology refresh policy? For services, the certification questions might be, how do you know your technology is effective in the long term? It's the same there. How do you show that you adhere to processes and procedures? What are your quality control and quality assurance plans? Do you retrain employees periodically? How often do you review and update policies? How do you verify that this is done? Do you have POCs that will substantiate this? The basic question is, how repeatable is your technology, and how do you know that everywhere you go, your technology will perform at the same high level? So, what do you mean by all these questions? As I was going through the different types of information, I noted that I used some words and phrases that might have not have had universal meaning. So I'd like to pause again and define some terms. In addition to meanings, please take this as a tip. Whenever you are using a word or phrase that might be defined as a term of art, please define it for us. Sometimes we think you might be saying something you're not. Or to quote from one of my favorite movies, "You keep using that word. I do not think it means what you think it means." So if there's a word in your lexicon that might not be ubiquitous, define it. So whenever we talk about developmental testing, we are talking about tests or events in controlled environments. We would expect that you are documenting the results to make changes before you move into operational tests. Operational tests are tests that subject the technology to conditions which are reasonably mimicking the terrorist threat that the technology is designed to consider. The key word here is reasonable. We know that all tests are not practical and that operational tests can be expensive. We are looking for some reasonable simulation. As noted above, if you can't do an operational test, can you augment what testing you have done with incident reports or after-action reviews?
Another word we sometimes use is suitability. Simply speaking, it is the ability of a technology to perform and be used in accordance with performance specifications. Suitability measures might include documentation of quality control plans, reliability data, and indicators of reproducibility between deployments. We are often asked to define a representative sample. In general, samples of supporting documents should be enough supporting documents of a given type, training records, personnel records, quality control reports, to demonstrate capability and/or effectiveness for your overall technology and deployments. A representative sample should consider and represent early state of sale, all types of services offered under the technology, geographic areas if geography is a bearing, and jurisdictional requirements affecting training or licensing requirements, vertical markets where different market segments have different hiring, training, or licensing, or other requirements or client requirements. A representative sample of documents should comprise a quantity that reflects the capability and/or effectiveness of your technology as a whole. For example, if your technology were a security service that operated in 5 states and offered security officers, K-9 teams, and risk assessments, you should consider the following: 3 to 5 records for each year from earliest date of sale, for each state in which you do business, covering all service offerings, or 3 to 5 in each service offering if your technology is not always deployed with all components included. An additional 3 to 5 records for any service offering where client requirements or jurisdictions are substantially different than the other record samples. So if 2 of your states of deployment have limited security officer licensing requirements, you would supply additional records demonstrating though you've ensured a baseline of personnel hiring and vetting records to those jurisdictions. Or if your technology has a baseline of hiring vetting procedures, you would caveat those deployments where the jurisdiction requirements are less and highlight that you continue to use your more stringent company hiring and vetting baseline policy. If you have unique service markets, for instance, hospitals or government deployments, you would also include a separate sample of records, 3 to 5 for each deployment, demonstrating that vertical markets unique requirements outside the baseline of other records. Thus, you would have provided representative samples of records for the common baseline deployments and the additional representative samples for any outlier deployments. Okay, so what types of insurance and financial information should I supply? In addition to the technical data we ask for, you might wonder what financial or insurance information to supply. Because the Safety Act is a risk and liability management tool, we need to understand which of your current insurance policies would satisfy the compensable third-party claims arising from, relating to, or resulting from an act of terrorism. For example, is it your general liability, professional liability, product liability, aviation, or standalone terrorism policy? Once you've figured out which policy applies, answer all the application questions relating to insurance. Please note that if you have more than one policy that apply, provide separate answers for each policy. If your policy will expire during the evaluation period, please provide updated information about the renewed policy. For instance, an insurance certificate is not enough because it never contains premiums, even if it does list out limits. It also fails to provide information on terrorism endorsements, etc. Applicants should instead answer all parts of question 16.1 for each policy separately instead of just providing an insurance certificate. If you don't have terrorism insurance, we will ask you to supply insurance quotes. If you have an insurance policy that just happens to exclude terrorism, the easiest way to do this is to get a quote to add coverage under the Terrorism Risk Insurance Act, better known as TRIA, to that policy. If you have no insurance, can't get a TRIA quote, or just think that the quote is too expensive, you can always get quotes for entirely new policies that would respond to a potential Safety Act claim. We recommend you get quotes for multiple limits of coverage. $1 million, $5 million, and $10 million is a good place to start. Remember, for any quote, make sure you ask your broker or insurance company to assume that the technology will receive Safety Act protections. We also ask all applicants to supply your most recent financial statements. This will include your income statement, your balance sheet, and statement of cash flows. If the primary named insured for your insurance program is an entity other than your company, such as a parent company, provide the parent company's most recent financial statements, income statement, balance sheet, and the statement of cash flows. For financials, we need the balance sheet and an income statement from the most recent fiscal year. At the same time, corporate level as the primary insured. Finally, we ask you to provide information on reasonable revenue projections. These projections are solely related to sales of the technology and shouldn't include any revenues you expect to earn from any other product or service. Is the technology not revenue producing? That's okay. Just let us know and then provide the technology's cost projections instead. When you're providing revenue or cost data, you should provide a projection figure for your current fiscal year, as well as each of the following 2 fiscal years, for a total of 3 years of projections.
All right, thanks for all that great information. Now, since I know that everyone out there is ultimately going to be successful, I'd just like to point out one very important to-do item once you receive Safety Act protections. Once you obtain a Safety Act designation and as applicable certification, you need to certify your insurance. Review the section in your designation letter called Liability Insurance Required. This section is typically on page 2 of your designation letter, and the amount is specific to your company. You certify your insurance by logging on to www.safetyact.gov and submit a signed statement on your company's letterhead, confirming that you meet the insurance requirement as specified in your designation letter. We have provided an example for you on the slide. So as Rachel was going through the insurance information, she was talking about TRIA. So what is TRIA and how does it affect you? In another area of insurance, you may have already been aware that there was a 6-year reauthorization of TRIA, which was signed into law by President Barack Obama on January 12th of this year. This ended the temporary lapse of TRIA, which expired on December 31st, 2014, after the Senate adjourned. In early January, both the House and the Senate in the new 114th Congress passed a TRIA bill to continue that program. TRIA, which is a federal backstop supporting the terrorism risk insurance market, will now be in effect through December 31st, 2020. Prior to the reauthorization, many insurers worked to reassure their policyholders about continuity of coverage on existing policies in the interim, though there was a grace period without grace periods or delaying exclusions. Policyholders were spared having to negotiate new coverage on TRIA during the short period the law had technically expired. The reauthorized coverage was made retroactive to January 1st, 2015. Since its original enactment in 2002, TRIA has established a risk-sharing partnership between the federal government and the insurance industry. Businesses have the option to voluntarily purchase terrorism coverage from insurers. In turn, the government agrees to initially absorb a portion of the cost in a very large attack. It may recoup its outlays within certain limits through future premium surcharges over a period of years. The amount of losses covered under TRIA remains at $100 billion annually.
So TRIA requires all U.S. commercial insurance companies to offer terrorism coverage for businesses. TRIA is designed to cover all commercial lines of property casualty insurance where terrorism risk applies and includes property insurance, business interruption insurance, commercial liability insurance, workers' compensation insurance, and surety bonds. Please note that nuclear, biological, chemical, or radiological attacks are not covered, so watch for exclusions if you have TRIA coverage. TRIA sets no pricing requirements or restrictions on obtaining coverage. TRIA includes a definition for certified acts of terrorism covered under the program. TRIA covers acts of terrorism committed by foreign persons against interests in the U.S. or against certain U.S. interests overseas. While the Safety Act and TRIA are not formally linked, we do find that the majority of our applicants do have some sort of TRIA endorsement on their policy. If you're having difficulties obtaining insurance, TRIA is one item that you should discuss with your broker.
Great. Thanks, Rachel. I guess to wrap it all up, we want to encourage all first-time applicants and applicants with first-of-a-kind technologies to submit a pre-application to begin the dialogue with OSAI, after which you can request a teleconference so OSAI can provide more pointed information that will help you to prepare a full application. Once you have prepared your designation application, you may want to schedule a pre-submission consultation through the Safety Act Help Desk so that we can provide feedback on any information gaps that may exist. Don't hesitate to submit questions to the help desk or request a phone consultation. Remember, there is no timeline associated with preparing and filing an application. Take your time, be clear, make sure each question is answered. Additional attachments are referenced in your narrative responses, and contact those POCs to let them know someone from OSAI will be contacting them. Let us work with you on this process. We tend to think that, though a small office, we're the friendly sort and willing to help you through the process. Please let us help you.
So before we take questions, we want to thank all of you for joining us today. And here is how to contact the Office of Safety Act Implementation, or OSAI, as we've been saying today. Remember, we are here to help you as you start or continue your Safety Act journey.
All right, now I think we're running a little short on time, so let's just go to the phone. Sandy, is anyone queued up online to ask any questions?
At this time, not yet. If they'd like to ask a question, please press star and 1 on your touch-tone telephone. Please record your name to be introduced. Once again, please press star and 1.
All right,
We do have a couple that are
excellent.
coming in. Just give it just a moment.
Okay.
Excellent.
We have a question from Daniel. Your line is open.
All right, is Daniel there?
Neil.
Your line is open.
I did the pre-submission. The question I had is, do I submit all of the documents with my application or just my application and just send what's requested later?
Okay, great. So just to make sure we get our terminology right, we have a pre-application form, which is a short form, and you don't need to give us all your attachments at that time. And then there's a pre-submission. If you've worked with our office to submit a draft copy, at that time we don't require you to submit all those attachments we've been discussing. Those would come with a full application for designation and certification. And if you have questions about your specific case, go ahead and submit a help desk ticket as soon as you get off the phone here, and someone will reach out to you quickly.
Okay, thank you.
Great, thank you.
And at this time, I'm showing no further questions.
All right. Well, I think we are ending very close to on schedule. We only wanted to take up an hour of your day today, but we do thank you all for joining us. And on behalf of myself and Rachel and our director, Bruce Davidson, we look forward to working with all of you on our nation's anti-terrorism mission. And we'll leave the chat room open for a little bit longer. But that concludes our webinar for today. Thank you all for joining.
Thank you.